Welcome to Solving Citizen Legal Encounters. All right, today we're going to be in Judge Hayward Court where an inmate decides he's going to take care of his case himself. Now, sometimes pro se goes good, sometimes it goes bad, depending on the attitude you have and what type of circumstance you're in. So let's check this case out. Let's go.
So, Mr. Brinson?
Yes, ma'am.
All right, Mr. Brinson. So, Mr. Brinson, you have motions before us for a motion for a plea in absentia for violation of probation, motion to dismiss detainer, and motion for pro bono attorney pro se. So I can grant you an attorney, but I'm trying to understand what it is you're asking for. So what I have is on your case 2018 CR 09436 before this court. You the first charge was no pros, improper lane change. The second charge, there was a plea to driving on a suspended or revoked license. And this case was then closed in December 10th of 2018. What is it you're asking for the court to do, sir?
I'll proceed without an attorney, so don't worry about the motion to for attorney. All right, but what I'm trying to do is I'm trying to resolve the whole issue today. I've been incarcerated for 8 years now, basically since 2017, and on an aggravated assault charging, which I have a 10-year sentence for, and that's these two detainers are the only thing that's keeping me from going to a TC to get out. So I'm trying to just resolve it all. Like I said, I've been basically locked up since then or whatever. When I first caught the charge, I was living in Texas, and when I was living in Texas, the judge was like, basically, we know you're not from here, so it was basically supposed to be a pay-only thing or whatever. But unfortunately, I had a warrant on me in Moultrie, which is Colquitt County. So I was sent to Colquitt County to go down there to resolve that issue. And I ended up staying.
You never completed the sentence in my case, is what you're saying? Yes,
ma'am. I mean, okay. I'll take
Just hold on a second. Let me figure out what that sentence was. Miss Wright, can you find that sentence in the case 2018 CR 09436, and let's see if there needs to be a modification so that we can go ahead and wrap that into whatever Mr. Brinson is doing right now.
Your Honor, I've already taken reviewing that.
Okay, go ahead, Mr. Tipton.
Okay, Your Honor. Case with regard to this case, count 1 was no pros, count 2 was a $500 fine. State would be willing to consent to the a modification of the sentence to 12 months to serve credit for time served, since he's been in jail for so long, and we'd waive all fines.
That sounds good. Ms. Wright, is that something we can do?
Yes, ma'am, we can do that.
All right. Did you need Mr. Tipton to repeat that?
Yes, Your Honor. Count 1's been null prossed already. Count 2 will be a suspended fine of $500, 12 months to serve, credit for time served.
Got it.
All right.
Thank you.
So, Mr. Brinson, the court is going to sign that amended sentence today. So that should relieve the retainer once it's filed and sent to the GCIC. Is there anything else that you needed, sir?
No, ma'am. How do I check up on it? Because I ain't gonna lie, ma'am. I done came a long way. I have stayed.
So, Officer Hemmings, is there an email address that we could send a copy to so Mr. Brinson could have access to it?
Yes, ma'am. You could send it to video.hearing@gdc.ga.gov, and we can get it to him.
Okay, so what I have is video.hearing@GDC, Georgia Department of Corrections initials, .ga.gov.
Correct.
All right, we'll get Mr. Brinson. Does that work for you?
Yes, ma'am.
All right, so that way you.
Oh, one last thing. Excuse me,
Yes,
ma'am. All right. What about remember that last year they gave me a court date last year, right? And just like I did this time, I had to go through the process of going through the officer, the court officer to get it, but they said I didn't have court then, so they put a detainer on me for a bench warrant. How do I resolve that?
We will do a search and I will release all bench warrants. Any of them would have come from me, so I can sign off on them. So
Thank you,
we'll
ma'am.
do bench warrant set aside. All right, and we'll send that to the same email address.
Okay. Thank you, ma'am.
All right, Mr. Brenton. Mr. Brenton,
Have a blessed day, ma'am.
the best thing to do is once you get out is to follow a different path. You got me? Don't come,
I learned my lesson. I promise
don't
you.
come back down the same path.
Trust me, I learned my lesson, ma'am. It's been very hard on me, but I really learned my lesson.
All right.
Really, thank you,
Your
ma'am.
Honor,
Have a blessed
Your Honor,
Thank you.
I may have missed it, but did you want the state to prepare that order, or will the court be preparing that order?
If you could prepare that, well, no, if you could prepare the bench warrant set aside, I'll appreciate that. And Ms. Wright is going to do the resentencing, and I'll sign that.
Yes, Your Honor.
All right. Thank you, Mr. Brinson. Thank you, Officer Hemmings, for making this happen.
Yes, ma'am. Have a good day.
Let's see, that went pretty good. He didn't have to say a whole lot. Luckily, it was an old case for him, and they went on and took care of it because it had been so long. But he was going to use an attorney, and then he was like, hey, let me just try this myself. Sometimes it works, sometimes it doesn't. Now, you think that's the end of the videos? No, it's not. So now we get ready to go into Judge Johnson's court, where there's a sovereign citizen in there. Let's go in and check out how this sovereign citizen is acting. Let's go.
Case number 25S00791. FY People State of Michigan versus Timothy Dansby.
Secretary on behalf of the people.
Illinois, P87446, Stephen in for the attorney of record, Bob Dominic, and appearing on behalf of Mr. Dansby, who stands to my right. Mr. Dansby, can you please state your full name for the record?
Yes, my name is Timothy Dansby, and I'm about to represent myself and I'll take counsel as an assistant, you know. So, I don't know who this being is. I never signed for no representation of counsel, so
Okay, you don't want a lawyer?
you
You don't have to have one.
I'm gonna need somebody because apparently I can't get a hold of no paperwork I haven't received my discovery back.
Well, that's what we got lawyers for, sir.
To the county machine to get to the lawyer very well. I was in the county, so it's paying me hard. So I'm gonna need some type of system.
Okay, well, that's what we got for you. Okay.
I'm gonna be representing myself.
Well, we don't have standby lawyers.
I wish all the courts said that.
So either you want a lawyer or you do not.
So first is I wanna go ahead on with the preliminary.
Okay, well, first of all, you're charged with retail fraud first degree. Now, first degree retail fraud is a felony charge. So the maximum penalty on this charge, let's see.
I believe it's 5 years.
Yeah, 5 years and a $10,000 fine or 3 times the value. You know what? Let me tell you something. You got a happy mouth.
I got a brain to go with you.
Well, you can have a, but you're disrespecting me.
I'm sorry.
Now I'm talking and you just cutting me off.
Eh?
So if nobody said you don't have a brain or anything, you just need to stop talking and listen to what I'm saying. All right. So this charge, you have a right to have a preliminary examination on this charge within 21 days of your arraignment date and within 7 days of today's probable cause date. So preliminary examination is the probable cause hearing where the prosecution puts on evidence to show probable cause to believe that this crime of retail fraud first degree was committed and that you were likely the one who committed it. And if in fact we have that hearing and they meet that burden, I'm going to send this over to circuit court for trial. If they don't meet their burden of proof, then of course this could be dismissed at this level. All right. So you understand all that. Now you don't have the discovery because I'm sure your lawyer probably doesn't have it either. Does Mr. Gonick have discovery?
Yesterday, we received paper discovery late yesterday. It will be sent to Mr. Danby today, and have not received any audiovisual discovery from my understanding.
I like the guy, if you don't mind, about the motion, you know what I'm saying, for the fact that I haven't been denied, you know what I'm saying, in the time denied. You know what I'm saying, when the prosecutor was conduct, oh, we should my government training, even though.
Sir. Okay, that's a lot of talking. There's no, where's the prosecutor? Yeah, but where's the prosecutorial misconduct?
Well, I should have had my discovery, y'all.
Sir.
Yeah.
Do you understand how this process works?
No.
Well, no, you shouldn't have had your discovery. Because this is the first hearing.
So in the first year, I don't prepare anything if I don't have any paper.
First of all, there is no preparing of anything just yet. Just yet.
I'm
Because
supposed to just stand here and just like, oh, yes, come on, this is not slavery. This is not it. This is not the one, you know. I am not the one. I don't care nothing about the United States. First of all,
apparently not.
Court.
You must not care too much about anything, sir. Okay.
I don't even have a license. What's your license number?
First of all, I don't know who you think you're talking to.
Now that's funny about the license number. And he's doing so much rambling and just putting the script in little pieces throughout the hearing.
But do you want to spend an extra 30 days in custody? No, you don't. You don't care. Obviously, that's why you're here charged with something.
What is your license number?
I don't have to answer you, and I don't answer to you.
Okay, is this a hearing or a domestic dispute?
And I'm not gonna start now. You need to settle down. You need to settle down. Okay, take him out of here, please. That's okay. He's having his moments.
He's having a sovereign citizen angry moment.
So we're gonna adjourn this, and I'm gonna waive the 21-day, 7-day rule for this discovery. Yeah, welcome to Friday. All right, so we'll give you what do you think? You could just need video?
Understanding, yes.
Okay. So we'll give like a couple weeks to do it.
Yes.
And, yeah, he's gonna want to see it, so you're probably gonna need to have him take a
I will
laptop over there to the jail and take his license to practice law to.
Yes.
Okay. All right. So the next probable cause conference on this charge is gonna be.
Excuse me. I just, to make a record as regards to that discovery, I do have paper discovery, which Sister Council has noted that has been tendered already. I do not have, does not appear that I have audiovisual discovery in my possession, but I will seek it should it exist.
Okay. If it does, it does. You know, if it doesn't, there's not much we can do. But we'll see if it does, and we'll come back on.
Court's available August 25th at 9:30.
Okay, the judge wasn't playing today. He talked himself right into the back. So we'll see what happens with him. He did all this rambling and kind of piecing the script together. I think he didn't have it memorized. He was trying to do what he could. So when all else fails, be angry in court. Now, the next hearing is going to be in Magistrate Garbo's court. Now, this individual in this hearing has the last name of Buckner. Now, he appears to look like Lawrence Buckner, the sovereign citizen we've been dealing with for a long time. But he definitely doesn't have the attitude of Lawrence Buckner, but they do look like they resemble each other. But for the record, I can't really say that they are related, but I did a little research and I think they are related. So you can do whatever research you would like to do. You're watching the video, you find something I don't, you can put it in the comments, but I'm not airing it here. So when I saw this hearing at first, I thought it was the famous Lawrence Buckner, but it's not. Let's go.
All right. Good morning, Mr. Buckner. Can you hear me?
Yes, ma'am. How you doing today?
I'm good, thank you. How about you? Okay.
I'm hanging in there. I'm hanging.
Oh, okay, good. All right. You have two files here with us at for arraignment purposes. Ms. Pate, were you able to talk to him about both files?
I was able to speak to him regarding both, but I did not yet have the complaint on the police report number 2554218. So I would respectfully request a formal reading of that complaint, but we were able to generally discuss it.
Okay, then I'm going to proceed. So you have two separate cases with us. The first is 25 FB 1346FY. The second file is WCSD 25-54218. Mr. Buckner, tell me your full and complete name for the record with your middle name, please.
Eric Lemuel Buckner.
Thank you. And Mr. Buckner, I'll advise you of your rights. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you can't afford an attorney, the court will refer you to the local appointing authority for them to make investigation as to representation. That's Ms. Pate. I'll sign that necessary paperwork so her office can continue to assist you. You also have the right to a probable cause conference within 14 days, a preliminary examination within 21 days, and you have the right to a trial. Do you understand your rights?
Yes, Your Honor.
Thank you. We'll proceed with appearances by counsel. We'll start with the people first.
Alex Chavalowski for the people.
An Assistant Public Defender Natalie Pate with and on behalf of Mr. Buckner, we would waive formal reading of the first complaint, and then as to the second case, I would respectfully request a formal reading. However, Mr. Buckner does stand mute as to all charges on both cases, and I would also ask to address bond on both when appropriate.
Thank you, Ms. Pate. All right, so both cases are the same charges. For the second case, it's alleged, sir, that on or about August 8th of 2025, that you were at 68 Township. It's alleged that you did assault, batter, wound, resist, obstruct, oppose, or endanger Deputy Sims and or Deputy Gambos, sheriff's deputies for the County of Washtenaw that you knew or had reason to know were performing their duties. That is a felony with a maximum penalty 2 years in prison and or $2,000. Do you understand the charge and the maximum penalty? Not do you agree or disagree? Do you understand what you've been charged with?
Yes, Your Honor. Go ahead. Yes.
See, he's soft-spoken and quiet.
I was told that it was resisting and obstructing. That's the wrong charge. That's what this reading up in here, resisting and obstructing, but on your half it's saying assault.
No, it's a bunch of different options. It's assault or resisting or obstructing or opposing. It's all one charge.
Oh, okay.
Yeah, that's just how the entire charge includes assaulting, resisting, obstructing, battering, wounding, opposing, or endangering.
Okay.
So you understand. It's just the title of the charge.
Okay, yes, ma'am.
All right, so we'll have you stand mute. I'll enter a plea of not guilty for you. I'm going to schedule you for your next court date for both files. It's going to be a probable cause conference with Judge Simpson. He will be able to see you on August 19th at 9 a.m. or as soon thereafter as the case can be called. That'll be at the 14A1 District Court. That is in person, not by Zoom. Do you understand?
Yes, Your Honor. Yes, Your Honor.
Very good. We're going to get you a notice to appear. You're going to receive additional information from the public defender as well. At this point, we are going to address bond. There are two parts to bond conditions. Those are things the court tells you can and cannot do. If you violate a condition, you're subject to immediate arrest. The other side of bond is whether you can be released today on your own or whether you'd have to post a bond in order to be released. I will hear from counsel. We'll start with the people.
Thank you, Your Honor. Your Honor, on both files, we were requesting a $25,000 surety bond. My colleague had put in a home confinement tether condition if Mr. Buckner is able to be released, as the first RNO that he's being rained on today resulted from an incident where officers were trying to arrest him on two separate domestic violence warrants. It is my understanding that those cases, the 2DV second cases, are currently set for trial, I believe in front of Judge Simpson in October. I point that out because I think that then surety, a monetary component is necessary per statute. In this case, due to the nature of the offense, Mr. Buckner running, hiding, while officers clearly announced that, and he knew that they were there to going to arrest him, makes him a flight risk. And in order to assure that he appears at his future court dates, the surety bond is necessary. I don't believe there was any other conditions I was requesting.
Thank you.
Thank
Ms.
you.
Thank you, Your Honor. I'm respectfully requesting PR bonds in both files. I can speak a little bit to Mr. Buckner's pending misdemeanor cases. He is set for final settlement conference in both of them in October. I represent him actually on the one in front of Judge Simpson. His other one is my understanding. He does have public defender representation, and that's in front of Judge Barr. That one is also set for a final settlement conference in October. This first resisting and obstructing case, the alleged offense date being May 28th of this year, does predate him being on bond for either of his misdemeanor cases. And I can represent to the court that Mr. Buckner reached out to me as recently as this past Thursday, because he had heard in court, the prosecutor did put on the record at his last pretrial that there were, as a resisting and obstructing in the queue. I don't remember the status if it was sworn out yet or not, but it was not yet authorized as a warrant, but she made counsel and of course my client aware that that was coming down the pipe, so to speak. So that Mr. Buckner then reached out to me this past Thursday asking if the warrant was issued and if he could take care of it. I relayed to him that given the JIS issue we've had lately in access, I couldn't check. And that was just very few days ago. I can also represent to the court that every single pretrial he has had since May 28th, he has been in attendance for, except for one, which he was in the hospital and did provide proof to me, which then I returned, which of course I submitted to the court, and he was reset for pretrial and no violation or negative consequence stemmed of that as he was hospitalized. And to that end, Mr. Buckner was attacked by a dog last May. He has many injuries that he suffers due to this. He has an MRI. He states to me that he has an MRI scheduled for this week. I do know that he has lots of medical appointments in general, as some of this documentation has been provided to me in the past. I do understand there's the new charge emerging from last night. And the fact is, yes, I do understand he was on bond for the misdemeanor cases when this alleged offense took place last night. I will acknowledge that it is an R&O, and I understand the allegation is that he ran based on Mr. Buckner's frequent appearances in court, both in 14A2 and then in 14A1, the case I represent him on. I do not believe him to be a flight risk. I believe if he was released today on PR bonds on both cases, he would be in attendance for his future court dates, unless God forbid he's in the hospital again. And I do have faith that he would then provide said proof to his counsel in the court. He does have full custody of his 14-year-old son and shared custody of his 9-year-old daughter. The mother of his 9-year-old daughter is currently in flux with her housing. So Mr. Buckner really has to care for both of these children. He also, for a living, he door dashes. He has a card note to pay. He has a lot going on. And given the nature of both of these cases being resisting and obstructing, he has a lot to take care of on the outside, and his track record of appearing for court, I would ask that he be released on his own recognizance for both cases today.
I have to say she did an excellent job presenting that case. But on the other part of it, I see a lot of cases during arraignment where people get in trouble, and as soon as they get in trouble, and it's a lot of times it's like heavy charges, they end up saying that they need to be out to take care of business at home or things that they need to do. But it'd be nice if they think before they do certain things. But of course, when we watch these cases, these are all alleged.
Anything further from the people?
No.
So I appreciate a track record, and he's missed a court date. I appreciate a track record on that. And when he missed a court date, that, yes, Mr. Buckner?
Oh, go ahead. Can I speak after you? I guess I don't.
No, because I'm going to make my ruling. So if there's something you want to say, remember you have the right to remain silent. Anything you say can and will be used against you.
Okay. No, I just
wanted to say.
I just wanted to say I do apologize for everything.
Don't apologize for anything, because if you apologize, that means you're acknowledging something went wrong.
Oh, no. It's not that. I'm just for wasting you guys' time. I'm sorry for that. That's what I'm saying. I do have children. I have a lot going on. I got a lot of health things going on. My car is about to get taken if I don't pay that. It's just a lot going on. I don't mind going back to court. I'm not no flight risk. I go to court. It's just the position that I'm in right now. probably about to lose everything within a week or so. And that's how it's looking.
Your attorney just took care of that. Why are you talking?
My DTE, I got certain things I take care of with that. I just got on a payment plan for that. My son is about to start school soon. I got to get him registered and stuff for that. So is my daughter. I'm trying to fluctuate between help her and her mom with the situation, her living situation. So it's just a lot going on, man. That's all.
So Ms. Pate did a very nice job speaking on your behalf, and you've worked with her before, so I would encourage you to let her do her job because she does it very well. Here's the problem that I have. So you missed court, you were in the hospital, something else happened, you got back to court when you were supposed to get back to court. Okay, I understand that, but we have continuing behavior that's not ending. So you have assaulting, resisting a police officer on May 22nd. And then while you're waiting to get this all squared away and you're in touch with Ms. Pate, which is great, you pick up another one. And so it's not a question for me of whether you're coming back to court. It's a question for me of, are you going to follow the rules and participate in society like you're supposed to? If every time you have contact with the police on a warrant, when they're trying to arrest you on a warrant, if you're not following them, I mean, I think they had to break down your door. Did they break down your door?
They broke down the door. They said I had a
Okay, so here's the thing. You have a 14-year-old kid inside, right? You have a kid that you're trying to, you just said you have a kid that you're responsible for, right?
Yes, I do. At the time, he was at his grandma's.
Okay, but he lives in that house with you, right?
Yes, ma'am.
Okay, and then you're trying to provide a stable.
Ma'am, I'm sorry. I don't mean, I was attacked over 20 times. I'm scared for my life.
Those of you who are familiar with the other Buckner, doesn't that sound familiar?
It's a lot going on that you don't know, ma'am.
There's actually a lot going on that I do know because I'm the one who handles search warrants. I'm the one who handles complaints throughout the county. So I'm well familiar with this address. I'm well familiar for what's going on. And I understand that you have a busy life with a lot of things going on and you're responsible for a lot of people. But consider this.
You give me one chance. I promise. I promise you. I promise I won't do nothing. I promise. I promise I won't.
I'm done. I'm not gonna have you continue to interrupt me. These are your bond conditions. You are required to appear for any and all court hearings and other places as directed by the court. You must notify the court of any change in address, email, or telephone number. All of your conditions, they will remain in full force and effect until changed by the court. You're required, or you're not allowed to violate any criminal law. You are to have no assaultive behavior towards anyone. Do not assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. Do not purchase or possess any firearms, ammunition, any gun components, or any dangerous weapons. Do not be with anyone who has any of those items. Do not leave the state of Michigan without prior permission of the court. No alcohol, no illegal drugs, and no marijuana. If you're able to post your bond, you will have home confinement at the. You'll be allowed to leave to go to any court hearings, meetings with attorneys, any medical appointments, and if you have to take your kids to school or any medical appointments for them. I'm going to set a $5,000 cash or surety bond on each file. Any questions, Ms. Pate?
So what is 5,000 cash or surety?
Your bond is $5,000 each file. So a total of 10 grand to get out of jail.
So, you know, okay, I don't know how that works. Okay. So is it 10%?
If you need a bail bonds person, you're welcome to do that.
Okay. Okay.
Ms. Pate, anything further?
Nothing further, Your Honor.
Thank you. Mr. Chabalowski, anything further?
No, thank you.
All right, sir, you're all set. We'll get your paperwork over to you. You are welcome to stand up and go to the door. Thank you.
Thank you. I have one last question, ma'am.
Yes, sir.
I don't, ma'am, I'm in debt right now. I don't have the money. Ma'am, I'm about to lose everything. And the PR will really help me right now. I have to pay my DTE. I got a lot of stuff to take care of when I do get out. I don't have $1,000, ma'am, that's all I'm saying, ma'am. I'm not perfect. I get that. I'm just asking you, Ms. Garnier, I haven't been in trouble in almost 10 years. That's what I'm saying. This just now happened. I mean, this just now escalated to this little situation. I get that. I've been doing good. I've been actually pretty
Sir,
good.
this isn't a negotiation. It's not a little situation. It's a large situation. You're trying to provide for a daughter, sounds like her mom, and your son. And when the police come to you and tell you that they have a warrant and you go inside and hide, they break down your front door. That means now your desire to do whatever you think you need to do for you has overtaken your ability to provide a safe environment for both of those kids and that woman, because there's no front door anymore. So you can't seem to control yourself when I'm trying to talk to you. You've interrupted me over and over and over again. It's not a negotiation. I'm concerned for the safety of the community. I'm concerned for the safety of the officers who are out there just trying to do their job. Oh, and one more thing, you said nothing, everything's been fine for many years, and then just this little situation. Well, there's this little situation, plus the cases that you have for domestic violence that Ms. Pate is assisting you in. So it's not one little situation. I think there are 4 separate cases that are pending. And these are felonies. The DVs may be misdemeanors, but they're victims in those cases as well. So I'm done. $5,000 per case, not a negotiation. We'll get your paperwork over to you. Thank you, sir.
Thank you, ma'am.
Thank you, Mr. Buckner. I'll be down to see you this week. You can step out though. Thank you, Mr. Buckner.
Okay. So I do have a bucket on those two.
I'm sorry, what was the question, sir?
I said I have a bond on those 2 cases, though. You said
$5,000 for each of these cases.
okay. I'm free to go, I guess, now.
Yes.
As soon as he pulled that emotional card, she shut that hearing down immediately. It was nice that she still let him ask questions, probably because he was being very polite. But other than that, she would have hit that mute button a long time ago. So I hope you enjoyed all the videos. Give it a thumbs up if you did. I wanted to throw this one in there. I know he wasn't really pro se or anything like that, but I saw it. I thought it was the other Buckner, and I just threw this in just because they're probably related, especially when he said, "I fear for my life." That statement, because Buckner was running that in his hearings. See you around on the next video.